Your department?
No, it was done under the direction of Snow Christensen and Martineau to basically look at valuing the land so that we could go to the company and make an offer.
Okay. So you'll see in the first page, it says the effective date of the appraisal. And Sean, you don't have this. If you need my copy, you're welcome to look at it. It says the effective date of the appraisal is October 23rd. Oh, go back 2 more pages there, Jeff. Very first page.
The very first page?
One more back. There you go.
Oh, right on the front.
Yeah, right on the front.
Okay.
The effective date of the appraisal is October 23rd, 2013. Do you see that?
Mm-hmm.
I'll represent to you that this lawsuit that we're talking about was initiated end of July or very beginning of August of 2014. So nearly a year after this appraisal was done. Help me understand what was going on with you, with the department, with Snow Christensen. I know it's a compound question, I'm just trying to speed things up, around this time of October 23rd, 2013.
Relative to the property.
Relative to the property.
Well, we had Snow Christensen and Martineau looking at the Magna Times. This property had come up at least twice that I'm aware of on tax sales and then got pulled for whatever reason. So we were looking to either trying to acquire the property through a tax sales provision, or we were also looking at having them do research if they could find shareholders or directors, which they were doing. They were able to locate directors, and as a result we wanted to have an appraisal that we could go talk to them with.
Okay. After the time this appraisal was complete and before the time the lawsuit was filed, let's peg it at August 1st, 2014, was there in fact a meeting with the directors where this appraisal was discussed?
We were going to have one. I still had to cover some political hurdles to make sure that we were going to be able to pursue this, and just a lot of other things. So I don't think there was actually a meeting that occurred, although there were telephone calls and emails that were going on between Scott Martin and the directors.
To your knowledge, prior to the time the lawsuit was filed, was this appraisal ever shared with any of the 3 directors?
The results of the appraisal was shared with all of them, I believe.
And what were the results?
That the value of the property was $480,000.
All right. Let's turn to, it's Bates number 21 of that same exhibit. That's where you are, Sean, I believe. Are you with me?
Bates 21, page...
Well, you're there. It's Bates number 21.
Okay.
The second sentence of this says, the purpose of the appraisal is to develop an opinion of the market value of the fee simple interest in the property. So was it your understanding in obtaining this appraisal that you guys would determine how much the property was worth in fee, meaning with clear title?
No, in fee.
Okay, what's the distinction? I said clear title, but I don't want to put words in your mouth. What's the distinction between clear title and fee?
It was basically with the status of the title of the company. It was looking at what the value was, and so I don't think we said in clear title.
Okay, so as is that a fair statement?
It says fee, it says what it says.
I'm trying to understand what his understanding was in getting this appraisal. I know what it says, but I was just reading it as a preface, trying to understand your state of mind in commissioning this. So is it fair to say then, you commissioned this appraisal to be done for purposes of identifying how much the property was worth as is?
He's already told you it was commissioned by Snow Christensen and Martin.
Who paid for this appraisal?
At the end of the day, we paid for it.
Okay. Did you know it was happening?
I did.
Okay. So you knew that Snow Christensen was getting an appraisal of the subject property.
Right.
That wasn't news to you after it was done.
It was not.
And the reason you had this appraisal done, making sure I'm understanding you right, was to find out what the as-is value of the property was with title defects and everything. Is that right?
It was to determine what the appraiser thought the value of the property was at the time.
Okay. The next page, Bates number 22, has a value conclusion toward the top of $480,000. Is that the same $480,000 that you referenced earlier?
It's $480,000, yes.
Okay. Okay. If you'll turn to Bates 51 of that same exhibit, please. Did you read this appraisal when it came in?
Not in detail. I probably just looked at the value that it was coming in at.
Okay. Here's what I want to understand. On Bates 51, it says land value conclusion. You see that?
Yes.
I read a couple sentences from that. It says, based on the preceding analysis and adjustments, the comparable land sales provide a range of value well above $525, yet somewhat below $4,688 per acres. A value just below $4,688 per acre would be appropriate for a buyer considering the property with a clean title. However, at present, multiple parties claim title to the land. A buyer therefore must consider the high probability of additional costs and risks involved with pending litigation to clear title to the land. So a couple things. Do you know what this appraiser is referring to when he writes pending litigation?
I don't.
Okay. So do you agree with this appraiser's conclusion that the property needs to be, what does he say, discounted to consider the multiple parties claiming title to the land?
No, I actually agreed with his 1,500 per acre was what was reasonably purchased for land going on out there. So I thought the 1,500 acre was more attuned to the value.
Okay, so let's read that so we're making sure we're saying the same thing. I'll continue. This reality suggests a near the bottom of the range of the comparables. Based on the data, a value of $1,500 per acre is concluded. So when you say $1,500 per acre, are you suggesting that's what the land with clear title should be, or that's what this land with the multiple parties claiming title should be?
I think that's what the land's worth, yes.
So when he says, and this is the second sentence, when he says a value just below $4,688 per acre would be appropriate for a buyer considering the property with a clean title.
Right. Where I would look at it, I would actually go back to page 22, and I would look to see if he listed any extraordinary assumptions or hypothetical conditions to get to his value, and he listed none. Okay.
Okay.
And so where I often see appraisers try and hedge their bets on their numbers is they will go back and they will put in those extraordinary assumptions reasons why they came to their value where it may be different than somebody else. So they came to a value of $1,500 per acre, which is the numbers that we've seen out there for purchasing land. So it did not strike me as unusual. It actually still scared me that there was enough uncertainty in this title, that we weren't going to get a warranty deed. All we're getting is a quitclaim deed. And so there's just, the value at $1,500 did not surprise me.
Okay, so turn to Bates number 50, please. You talked about a concept of extraordinary assumptions that are made by appraisers. The last bullet point of this page is adjustment summary, which reads, the sales are compared to the subject and adjusted to account for material differences that affect value. The following table summarizes the adjustments we make to each sale. would this table then that follows on page 51 be those extraordinary assumptions you're referring to?
No.
Okay.
That's standard adjustments that all appraisers make when they make appraisals. They try and adjust it how one property compares to another property.
Okay.
But
So,
no, they will list their extraordinary assumptions.
do you agree that the property is worth more with clean title than it is in its current state?
Not necessarily, no.
Uh-huh.
Also, given the fact that there's been a recent purported sales through this sales agreement for $100,000 less than we're willing to pay for it.
Well, you said there's been a sale, meaning a sale is
purported
actually...
sale, and quitclaim deeds, and so the 380,000 and some more discounted off of that. So
I guess what I want to understand is, do you disagree with this statement? A value just below $4,688 per acre would be appropriate for a buyer considering the property with a clean title.
yes, I do.
You disagree with that?
I do.
You think the appraiser got it wrong?
I don't think the value's at 4,688. Don't.
All right. Do you believe that $1,500 per acre is the price with clean title or with multiple parties claiming an interest in it?
I think it's the price that I'd be willing to pay for the land. And so an appraisal doesn't make a market value. It's a willing seller and a willing buyer that makes that market value.
I'm just as confused as perhaps you are about this. Maybe you're not confused. I don't want to put words in
Right.
your mouth, but I'm a little perplexed as to why the appraiser is delving into title to a property. I've never actually seen that in an appraisal.
Me neither.
And so what I'm
But-
trying to get at is, if the value is $480,000 as is, why hasn't Salt Lake City cut the check to the directors today and bought it as is?
Because it's tied up in this lawsuit that your clients filed and has slandered the title, and I'm responsible for public dollars, and I'm not going to go through a process where I'm committing $500,000 of public funds without going through and defending the title to this land.
Okay, but isn't that what this appraiser is suggesting is the basis for the discount? The reason you're getting it for $480 is because you're buying it as is?
No, if he had that strong objections, he would have put it in his extraordinary assumptions, and he didn't. There's two places every appraisal I get, I look at the value, and then I go back and I look at the extraordinary assumptions.
Okay,
And he had none. I assume it's a he.
I believe it is. I believe it's two he's, as a matter of fact. If we do the math at the $4,688, we get approximately $1.5 million. And you don't believe that land, this land, with clean title is worth $1.5 million. Is that correct?
I'm not sure I would pay that for that land.
All right. How much would Salt Lake City pay to protect the watershed on this 320 acres of land?
Objection, why is this relevant to anything?
480,000.
How is it relevant?
He's answered your question.
Oh, okay. Sorry, you're
480,000.
not anymore?
No.
Help me understand how one of the claims in the lawsuit is trespass. I believe that's one of the causes of action. Let me just make sure.
You're referring to the counterclaim.
What's that?
You're referring to the counterclaim?
Yes, I'm referring to the counterclaim. Okay. Yes. Okay, it's Exhibit 16.
Which has been marked.
I'm on page 16. This is the third cause of action, titled trespass, and this is a counterclaim against all of the third-party defendants. I want to understand, in what way does any of the third-party defendants' occupancy of this land or ownership, I recognize it's compound, again, trying to speed things up, damage the watershed?
Well, again, they were up there. They supposedly had done this agreement with was it Quality of Animal Life or Friends for Animal Life to cut and remove trees. That damages the watershed. They don't know what other activity they were up there doing. They're trying to grade stuff. They ended up paving a piece down by Big Cottonwood Road that changes both the quantity and quality of water that comes off of this land.
Okay. Wasn't that road already compacted previous to that paving?
Wasn't paved with oil, no, it's not.
Okay. So the idea is that the watershed is damaged if some trees get cut down and because of paving. Is there anything else?
I'm not sure what other activities they were doing up there. I know at one point Evan Johnson sent me a picture of an outhouse that was built. I don't know if it was on this property or another property.
When did he send it to you?
I don't know, 3 or 4 years ago.
Okay.
Kind of with like, haha, catch me if you can.
Did he indicate whether it was this property or another property?
No, he didn't indicate where it was.
Has Salt Lake City, well, let me rephrase the question. Have you been made aware of a bridge that crossed, what's it called, Big Cottonwood Creek? Is that what it's called up there?
There are numerous bridges that cross Big Cottonwood Creek.
Okay, on the subject property?
I'm not aware of one on this subject property.
Are
There's
you aware?
one upstream from this property.
Okay. Are you aware of a time where a bridge on the subject property has been destroyed?
I'm not.
Okay. How about the one you just referenced, just upstream from this property?
It was a bridge that Evan Johnson built upstream from this property.
Okay. Is that on property he owns? Do you know?
I don't recall the property ownership. It was to access property here.
I'm trying to get sort of the heart of the damages that are being alleged in this case, because it's Salt Lake City's goal to purchase the property, but I'm trying to understand, aren't there zoning laws in place to protect the watershed that could be just as effective as actually owning title to the property?
No, zoning laws are never as certain as ownership.
Is there something that Colonia Mining, or excuse me, Cardiff Canyon LLC could do with this property should it prevail in the lawsuit that it couldn't otherwise do to the detriment of the watershed?
I don't understand your question.
Me neither.
What I'm getting at is if Cardiff Canyon, under the assumption that Cardiff Canyon prevails in this lawsuit and owns title to the property, what acts could it do to damage the watershed?
It could propose to build development up in there. I've seen proposals for ski area, lift towers up in there. They had Scroggin kind of develop a little ski area development.
But doesn't Salt Lake City control Salt Lake County and Salt Lake City controls the zoning up in the canyons, correct?
There are zoning laws in the canyons, correct?
And so any development proposal could be terminated or its fate determined by Salt Lake City and Salt Lake County, correct?
The proposal would be per the zoning code. All those zoning codes have appeal processes and they go potentially to the courts at the end of that. So it's not a sure process, absolutely not.
Okay, so the goal is to completely control the watershed so that you can determine its fate as the owner.
Our goal is to secure watershed property to protect both the quality and quantity of the water, yes.
Okay. Do you have a, would you characterize your relationship with Evan Johnson as positive or negative?
I would characterize it as non-existent.
Okay. Notwithstanding the fact you have been involved in meetings with him and
A
case,
meeting.
one meeting with him, and the fact that you've been involved with the lawsuit that went to the Supreme Court of Utah? You said there's still a non-existent relationship between you and Evan Johnson?
Personally, I have no contact with Evan
Okay. But he does send you emails,
routinely.
and you don't respond to those emails?
I don't.
Okay. It's the same question. Would you characterize your relationship with Paul Southam as positive or negative?
Have no relationship.
Josie Southam?
Never met her.
Wayne Crawford?
Met him a few times, but again, have no relationship one way or the other with him.
You mentioned earlier that the property went to tax sale a couple times.